Good afternoon and welcome. My name is Andrew Mackenzie. I'm the Chief Executive of the Scottish Arbitration Centre, and I'm delighted that the Centre is hosting this virtual conference today. COVID-19 and the resulting restrictions mean we cannot hold our usual in-person annual arbitrator training day this year. But like arbitration itself, the Centre has adapted to the new way of working and wanted to provide a virtual event instead. The event will explore the flexible nature of arbitration and our move to virtual. I'm grateful to our speakers and will leave Brandon to introduce them shortly. I would like to thank FTI Consulting for once again sponsoring our annual conference and ICA for supporting this event. Firstly, some Zoom rules before I give a very brief update on the Centre. Please use the chat box to engage generally, as we'd love to know who's out there and where you are in the world. But don't use that for questions to the speakers. Please put your questions in the Q&A box. And Brandon and the speakers will be able to see your questions there. In terms of the Centre, there have been some significant changes since the last conference. In April, our directors became the members of the Centre as founding members. CIARB, the Law Society of Scotland, RICS and the Scottish Government all agreed to step back to allow a more independent body to develop. We're grateful to these organisations and also to the Faculty of Advocates, another founding member, for their support in the initial years of the Centre. And we continue to work collaboratively with these and other arbitral bodies. The Scottish Government also continues to support the Centre, and this includes annual grant funding. The Centre is now working on strategy and governance development as we begin this new era. We've also been busy preparing for ICA Edinburgh. We've had to postpone the Congress on 2 occasions now this year, which created significant work for us and ICA. Nevertheless, around 600 of our delegates remain committed, regardless of changing dates, and we recently opened registration for new delegates. So we look forward to delivering this most prestigious arbitration event between the 26th and the 29th of September 2021, and hope you will all join us in person in Edinburgh at that time. So now I can hand over to the chairman of this event. He's also the chairman of the board of the Scottish Arbitration Centre, Brandon Malone. He's a solicitor advocate in Scotland and a solicitor of the senior courts in England and Wales. Brandon is also an arbitrator, adjudicator and mediator. He's a member of the ICC Commission on Arbitration and ADR. He chairs the ICA New York City Bar CPR Institute Working Group on Cybersecurity in International Arbitration. And of course, in September 2021, Brandon will chair ICA Edinburgh. So, Brandon, over to you.
Well, thank you, Andrew, for that very full introduction to the conference and indeed to me. Welcome, everyone. It's great to have everyone here at another training day. We have a big announcement I'd like to make before we start. The Arbitration Centre was set up almost 10 years ago, and I put together the blueprint for it and presented it at the Scottish Parliament. And at that time, I didn't realise that I was going to end up being on the board, let alone chair it, let alone still be the chair 10 years later. But here I am, and I'll be chair for a little while yet, but I'm extremely pleased to announce that we have identified my successor as chair. And that is someone who will be known to, I'm sure, all of you, and needs little introduction, but I'll introduce him anyway. Lord Glennie, Angus Glennie, is going to take over as chair of the board when I step down, which will be after the ICA Congress, which, fingers crossed, will be in September next year. So Angus is stepping down as a judge today, I believe, and will join our board immediately after that as vice chair, and will stay with us as vice chair before taking over as chair after the Congress. So that's really excellent news. I am absolutely delighted about that. We have a few other directors joining us too. We have Mary Thompson, who is a chartered arbitrator, an accredited mediator, and has been based in Hong Kong, but now has moved to Edinburgh. She's a barrister at 36 Stone Chambers. We also have Peter Scott Caldwell. I think Peter is on the conference, so welcome, Peter. Peter he began his career as an engineer. He is from Scotland. He's then been in Kenya and Qatar before being Secretary General of the Hong Kong International Arbitration Centre between 1990 and 1998, and it was a big factor in their growth and success. So we're delighted to have Peter on the board. And also, finally, Gillian Carmichael-Lemaire is joining the board. She's a dual qualified member of the Paris Bar and a Scottish solicitor. She's based in London at her own practice, Carmichael-Lemaire. And has had having started out as a litigator in Glasgow, has had a 35 career in international dispute resolution. So the fact that we have been able to attract such expertise and diversity to the board is, I think, a testament to the development and success of the organisation over the years, over the last 10 years. And as I say, we're all at the centre extremely pleased about it. So that's our big news for today. And now I have a further great pleasure of introducing our first speaker, and that is Lucy Reid. Lucy is an arbitrator at Arbitration Chambers based in New York. She's also one of 2 vice presidents of the Singapore Arbitration Court and a member of the US Council on Foreign Relations. Until last year, Lucy was director of the Centre for International Law and professor of practice on the Faculty of Law at the National University of Singapore, and was previously a partner at Freshfields, working in Singapore, Hong Kong, and New York. She's also an editor of the Oxford International Arbitration Series and has served on the editorial boards of the Journal of International Arbitration and the ICSID Review. Crucially, for our purposes today, Lucy is president of ICA, the International Council for Commercial Arbitration, which will hold its prestigious Congress in Edinburgh in September next year. And Lucy is going to talk to us about the move to virtual ICA and its approach to selecting jurisdictions to host its prestigious Congress. So over to Lucy, and I will switch off.
Thank you. Am I on now? Yes. Thank you. Good morning for my part. Good afternoon to others. I'm on the East Coast of the United States. I want to thank you, Brandon, for that kind introduction. And I realize that most of what you said is relevant to arbitration, but not as relevant as some points that I should have given to you for my introduction, which are that my sister, who's in charge of our family tree, has recently sent me my updated DNA information, which shows that I am 42% Scottish, and my middle name is Ferguson. So I have several personal connections that bring me, looking forward to bring me to Edinburgh. As president of ICA, I want to thank the Scottish Arbitration Centre for the invitation to deliver this keynote, and of course welcome Judge Glennie and give congratulations to the other new directors. ICA has built very close links with Scotland since the award was made in 2016 to have the ICA Congress in Edinburgh in 2020. And as mentioned by Brandon, there have been 2 postponements. And I want to thank the Center for all the hard work and the patience that has gone in to rescheduling now for September 2021. It has not been easy. It's particularly an honor for me to address a topic that is front burner, but we can't talk about it enough, which is the move to virtual. And to me, there's an obvious connection between the move to virtual and the theme of your conference today, which is flexibility and adaptability in international arbitration. I am going to try to be visual and virtual and put up a few slides for you. But I was failing before. Yes, now we have that. There, we'll go to slideshow. Thank you. I've learned in giving these seminars that one of the benefits of having a few slides is my face doesn't have to be quite so big early in the morning for everyone. So here's my basic proposition. International arbitration is per se flexible. That is the coin of the realm. Flexibility in procedure based on consent of the parties most of the time until they ask for too much is the very foundation of international arbitration. And in keeping with this key trait, when the COVID-19 pandemic started to change life as we know it in March of this year, arbitration practitioners and institutes made very quick adjustments. After a few Zoom or WebEx trials and errors, some more embarrassing than others, most of us have learned how to navigate the multiple virtual platforms that we're using rather skillfully. I will qualify that by saying it depends in part on one's generation, and it depends in part on whether one has a grown child who is a computer engineer, which I do. Although I have to admit, usually when I ask my son a question, he just says, Google it. So there you go. More seriously, online dispute resolution is not entirely new. There are regions such as China, and there are sectors that, as with intellectual property and domain names, that have been using online arbitration for quite some time as their rule rather than the exception. Yet in our universe of complex commercial arbitrations and investment treaty arbitrations, there historically, well, I could say there's been a reluctance to doing online arbitration, but I don't think it's so much reluctance. It's much more that we just never really thought about it as an option. There were exceptions. For example, a video conference when an arbitrator missed a plane, or when there was a witness who really could not make it to the hearing for a short cross-examination, and we would use a more or less effective video con in the hearing room. It has its role. I remember very well when I was a commissioner on the Eritrea-Ethiopia Claims Commission, which was a humanitarian law commission. There had to be a cross-examination of a surgeon in Eritrea, and there absolutely was no point in having him spend a week in The Hague to be on the stand for no more than an hour. So the cross-examination was held of that doctor when he stepped out, literally stepped out at a convenient time, a safe time from his operating room. So that did work, and it does work. But until this year, hearings, even half-day hearings or one-day hearings, have been held by default in person across most of our arbitration lives. Now, the global pandemic, obviously, and the restrictions on travel and gathering together in places necessitated a dramatic increase in our learning curve and use of virtual meeting technology. Counsel, arbitrators, parties, witnesses, everybody has had to adapt swiftly, as I say, and that's what we do in arbitration. So now I think it's safe to say the default has flipped. Today, as COVID-19 still ebbs and flows, and I think unfortunately flows more than ebbs through early next year when we have vaccines, we will be having in-person hearings as the default. Based on the experience so far, including my own, I think, again, it's safe to say that the move to online hearings in our sector has been a success, as it has in various court systems around the world. Now, naturally, some participants remain resistant to virtual hearings. Sometimes there are good reasons, sometimes it's strategic, but arbitrators are learning to deal with that. Most of us are adapting because we have no choice. We've had to do it. Now, obviously, one reason for the success is the advanced technology available to us in this time and place. There's affordable and reliable video conferencing, many platforms available to allow us to connect. And it's really quite amazing for those of you who've done a big hearing. We've got arbitrators, counsel, witnesses, experts, interpreters, court reporters, document managers, assistants, all online at the same time with relative security. And we also have the benefit of technology to support the hearings with exchanging pleadings on shared platforms and document bundling electronically. That's being done by some of the best, we would call them hearing concierges. But equally, we often forget that equally important has been the very generous information sharing that's been done. We have access to excellent commentary online on practice points and procedural points. And I'll just mention one, and that's by our ICA governing board member, Professor Dr. Mohammed Abdul Wahab, who has an interesting and short and readable piece called Exculpating the Fear to Virtually Hear, a proposed pathway to virtual hearing considerations in international arbitration. Now, at ICA, we have a project that I find actually useful and exciting, which is a collaboration on comparative research on the question of whether a right exists to a physical in-person hearing in international arbitration across some 100 jurisdictions. This is led and edited by Professor Giacomo Elguata at Roma Tre University, and James Hoskins and Yasmin Lalou at Chaffetz Lindsay in New York. We anticipate that the preliminary results of the study will be available on a knowledge hub on ICA's website later this month or early next year. And then the whole project, the collection of information from the jurisdictions and several, several pieces of commentary or studies of things like due process in online hearings will be published in an ICA report and updated on the website. For those of you who haven't followed this, there are some jurisdictions that prohibit online hearings, or I should say it a different way. They require a physical in-person hearing unless the parties all agree. There are other jurisdictions that have legislation that specifically allow for virtual hearings, and most are in the middle, and therefore we're looking at, of course, case decisions which are starting to come out from the courts. The other big information sharer are the arbitration centers. ICC, ICSID, SEAC, others have put forward checklists, guidelines, protocols on how to run these hearings. So we now have, this is December 2020, we have a wealth of information on how to do this, whereas as recently as last March and April, we were pretty much in the dark. A lot of the webinars that are happening right now stop with the points that I've just made. In my view, though, these are only the first chapters in what I call the pandemic flexibility and adaptability of international arbitration book. So far, we've pretty much mastered the basic technology, and we have succeeded in mimicking in-person hearings online in 2 dimensions, more or less. In the next chapters, I think we need to consider and debate some more challenging questions, and I'll list a few. Is it possible to preserve the essence of a physical hearing online? If so, why bother? Why just try to mimic? Should we be looking for different paradigms for online versus physical hearings? How is due process preserved? How is it maximized? How will we change our views of due process? Will there be long-term changes on styles of advocacy, cross-examination, and tribunal engagement in 2 dimensions? And for me, very important, and something I still can't learn enough about, how can cybersecurity be increased and sensitive data be protected when we're all working on these sensitive cases on the internet? Is Zoom bombing really gone for good? Now, ICA's been considering several of these questions, and I just want to mention cybersecurity and data protection. Somewhat presciently, in 2019, ICA launched a project on cybersecurity in international arbitration together with the New York City Bar Association and the International Institute for Conflict Prevention and Resolution. And as you heard, your own Brandon Malone is the chair of the working group. They've published a very readable, useful cybersecurity protocol, which will be the subject of more discussion and I think a lot of questions, Brandon, at the Edinburgh Congress. On data protection, I can tell you that arbitrators in particular, whether they're in Europe and England or outside, are struggling to adapt, to understand and adapt to the new rules, including the GDPR. To this end, ICA and the International Bar Association established a task force last year, and they have a draft guide on data protection in international arbitration proceedings that's out for comment now and will come out in early 2021. As a last point today, let me address the, I think it's a front burner, at least it's very popular, question of whether our pandemic forced migration to virtual will change international arbitration forever. In other words, for this conference, will our laudable flexibility become inflexibility post-vaccine? Personally, I think not. There are many positives to virtual hearings. There are lower costs, there's lower travel time, there's lower carbon being put out into the atmosphere, and we're starting to see more opportunities for diverse arbitrators and younger practitioners to appear without all that extra expense of travel. But there are many negatives, or maybe it'd be better if I call them challenges to virtual hearings. Sitting at punishing times across time zones. I've had many all-night sessions, and others have had all-night sessions. We've been trying to flip that so everyone isn't up all night. I think that's even worse. We're dealing seriously, particularly with arbitrations in developing countries, with unequal access to the internet, to hardware, and to software, and the effect of screen fatigue. So my view is that I think, and maybe safer to say I hope, that we'll be making good use, thoughtful use of what we've learned and remain virtual for the right things, for procedural conferences, for oral argument on motions or applications where there are no witnesses, for oral closings a few days after the hearings, giving the counsel a bit of time to think, and for deliberations amongst the arbitrators. But having said that, I predict that we will, as soon as we safely can, return to meeting in person for longish hearings, particularly those involving multiple witnesses. That's driven in part by the logistical concerns that I've just gone through, but it's driven even more for me by the perception, I think the reality, not a perception, a reality that in-person human interaction with its immediacy and its nuance and its body language, and its fun sometimes, is important in evidentiary hearings, no matter how powerful our technology is in two dimensions. Now, I have to tell you that others disagree, and I'm starting to hear more often arbitrators and even counsel, and sometimes clients, predicting that tribunals can and should insist on almost all virtual, almost all the time. To me, that sounds like the opposite of flexibility. So we will have to see how it goes. And we will continue this conversation on the adaptability of international arbitration with a panel and many Q's and A's, I think, on the virtual world at the ICA Congress in Edinburgh next September. And I want to close by saying I wish I could play for you or show you on screen how many of my colleagues are telling me how excited they are about Edinburgh, because they're predicting it will be the first time that the community gathers again in person, to be really together for the first time in an age. The program committee, again, I think with some ICA prescience, chose a couple of years ago the theme of arbitration's age of enlightenment. So we will be drawing inspiration from the events of this past difficult year, including the transition to virtual, and looking at how we can enlighten ourselves on how arbitration has and continues to adapt. So I'll end with my favorite slide these days, which is I'll see you in Edinburgh. Thank you very much. And on behalf of ICA, I wish you a very successful conference. I apologize, I cannot stay on very long because as former head of the Freshfields Arbitration Group, I'm going to have to sign off and show my face at the Freshfields Arbitration Lecture, which is starting soon. Thank you, Brandon, and thank you all.
Well, thank you very much for that. I'm just trying to find my camera button. Here we are. Thank you, Lucy. That was fantastic. And thank you for that overview and for your kind words about Scotland and the Congress. And thank you very much for joining us. I know you're very busy and you need to move on to your next event. So we now move on to the next speaker, and that is John Campbell QC. Now, John is a member of Famous Advocates and called to the Scottish Bar in 1981 and to Lincoln's Inn in England in 1990. His primary practice areas are in town and country planning, energy and land and rural law. He has acted as counsel in arbitrations and also sits as an arbitrator. He teaches and writes domestic and international arbitration law and practice. He is an APTA panel arbitrator and a fellow of the Chartered Institute of Arbitrators, and John is also an honorary fellow of the Royal Incorporation of Architects in Scotland and chairman of the SHBT, Scotland's largest building preservation trust. And John is going to discuss Scottish arbitration. So over to you, John. We still have John?
Brandon, it's Andrew here. I'm not hearing from John at the minute, but I think we were going to actually show the minister next.
Oh, I do apologise. We're going to show the John. Sorry, I think we're
No, not at all. My internet suddenly cut out there for no reason.
No, we have a message from the minister.
Yes.
So we'll do that first, then we'll come back to you, John. Apologies for that.
Well, let's hope it. Okay, thank you.
Yes, so my apologies for the mistake in the order there, ladies and gentlemen. We now have a message from Ash Denham, MSP. Ash Denham was appointed as the Minister for Community Safety in June 2018 after being elected as MSP for Edinburgh Eastern in May 2016. And as Minister for Community Safety, she has arbitration as part of what she oversees for government. So, Ash Denham. Roll tape.
I want to start today by thanking Brandon and Andrew and congratulating the Scottish Arbitration Centre for organising today's conference. The Scottish Government provides annual funding to support the crucial work that the Centre does to promote arbitration to businesses in Scotland and to promote Scotland as a global centre for arbitration. Arbitration is a commercial, cost-effective and confidential method of resolving disputes. And with the Arbitration Scotland Act 2010, Scotland has a modern and innovative arbitration regime. From a relatively low starting point in 2010, arbitration continues to grow in respect of commercial disputes in Scotland. It remains the dispute resolution method of choice in respect of commercial leases, and rent review disputes use arbitration. It also appears to be making a comeback in construction contracts and is being used in renewable energy contracts. Arbitration is also popular in consumer, employment and partnership disputes and is being promoted for personal injury matters and in certain aspects of family law. There are four main reasons for the growth of arbitration. Firstly, arbitration is often faster than litigation. Disputes referred to arbitration can be disposed of in a matter of weeks with sufficient cooperation of the parties. And it's also possible for parties to limit the duration of the arbitration by agreement. Secondly, arbitration can be more cost effective than litigation because it's faster to resolve the dispute. There's no requirement to have a substantive hearing. So again, there can be further savings where matters are determined on the papers. And the restrictions on the right of appeal to challenge an arbitral award provide cost savings. And thirdly, unlike litigation, arbitration is confidential. Unless altered by agreement, all parties to the arbitration have a duty to maintain confidentiality in respect of confidential information. And a breach of confidentiality is actionable and can be prevented by interdict if caught in time. If a breach of confidentiality can be shown to have caused loss, that loss can be recovered through the courts. However, with the COVID-19 lockdown impacting court business and creating a backlog of litigation work, the fourth benefit of arbitration is flexibility, and it's a valuable and attractive attribute, allowing parties to drive matters forward where there is agreement. And this flexibility has been demonstrated in the ability of arbitration to adapt and respond during the COVID-19 crisis. Due to the COVID-19 restrictions, a physical hearing is not always possible, and this has resulted in arbitrations being carried out online in recent months. Arbitral institutions have adapted, where required and at very short notice, to this new and this different way of working. Hearings are also being conducted virtually. And virtual arbitration is a forum for news and recent developments in the law and practice of arbitrating on web-based meeting platforms using online communications technology. The ability of arbitration bodies and professionals to adapt so quickly to COVID restrictions has been impressive and allowed dispute resolution to continue. But it also, again, demonstrates the flexibility that arbitration offers. Scotland's businesses and organisations can be confident that arbitration is an effective and efficient mechanism for resolving disputes faster, more cost-effective, and is sufficiently flexible to respond to their demands. And we are fortunate here in Scotland to have a modern and innovative arbitration regime, underpinned by world-leading legislation contained in the Arbitration Scotland 2010 Act. The legal system in Scotland makes Scotland such an attractive place for the resolution of international disputes. A judicial system of the highest integrity, a forensic approach to fact-finding, skilled professionals, an approach to commercial contracts which values party autonomy and which seeks to meet the reasonable expectations of the parties. If they want to choose their judge and to exclude any appeal, they can proceed by way of a summary trial in the Court of Session in Edinburgh. And if the facts are not in dispute, but the parties need an authoritative ruling on a point of law, they can proceed directly to the appeal court by way of a special case. Or, if the parties want confidentiality, to choose an expert decision maker, to choose the law and procedure which will be applied to the case, they can proceed to arbitration under a modern, comprehensive arbitration regime set out in the Arbitration Act. As the judge observed in one of the early cases under the Act, it marks a new beginning for arbitration in Scotland, recognising the desire in this field for party autonomy, privacy and finality. Many of the reported cases on the Act have catchy names like Arbitration Application Number 3 of 2011, which, if not very memorable, ensures the confidentiality of the process. The grounds on which appeals may be taken to the court are limited. They encompass jurisdictional appeals, appeals on grounds of serious irregularity, and legal error appeals. The parties may exclude legal error appeals, and in any event, they may be brought only by agreement of the parties or with the leave of the court, which may be granted only on limited grounds. The Scottish courts are strongly supportive of the arbitral process, and they will stay any action if the matter in dispute is subject to a valid arbitration agreement. They have rejected any suggestion that challenges could be brought to arbitral awards other than in the strict terms of the rules made under the Act. Applications under the Act will be dealt with by nominated arbitration judges. Next year, Edinburgh is the host for the ICCA conference from the 26th to the 29th of September. The conference theme, Arbitration's Age of Enlightenment, is a nod to Scotland's contribution to the Enlightenment in the 18th and 19th century, when people like Adam Smith and David Hume reshaped our understanding of the world. That conference will provide another great opportunity to engage and interact with lawyers and arbitrators from around the world, and to reflect and to learn, a real opportunity for enlightenment. We're very proud that Edinburgh and Scotland was chosen to host the conference, and the conference will put Scotland in the spotlight between now and 2021, and it will give our great nation an unprecedented profile in the international legal sphere. In the meantime, the Scottish Government is working collaboratively with key partners as part of a collaborative partnership to promote a seamless service for dispute resolution to empower our citizens, our businesses, and our organisations to resolve disputes effectively and efficiently, and to promote Scotland as a world centre for dispute resolution.
Okay, so that was Ash Denman, MSP, and we're very grateful to Ms Denham and to the Scottish Government for the support they have given to the Centre over the years, and for providing us with that piece today. Now, a quick reminder that there is a Q&A function. If you have any questions as you go along, feel free to ask them. I'm not saying we'll take them now, but we'll save them up and we'll get to them in due course. Now, our next speaker is John Campbell this time. I introduced him fully last time, so I won't introduce him again, other than to say that I'm sure it was John Campbell who first really got me into arbitration properly. I'd done it for a number of years, but John asked me to come along and speak at a CIARB event many years ago, more than 20 years ago, I think. So, John, it's your fault I'm involved in all of this. So thank you very much. So over to you, John. Are you able to turn your camera on? Fantastic. Thank you, John.
Thank you, Brandon. Good afternoon, everybody. Screen with you. Brandon, I hope it wasn't 20 years ago, but it might have been, I suppose. Time goes past. Anyway, thank you for the introduction, which I didn't hear because my internet cut out at a critical moment. If I share the screen for the slides that I have, can you just confirm to me that that's working all right. No. Sorry. We did rehearse this earlier on. Can you hear me, Brandon?
Yes, I can hear you. We can see your screen's on, but I think if you press slideshow, it may come up and take up your whole screen. Otherwise, you'd have to come out again and go back in. Have you tried pressing slideshow on it?
Yeah. Your screen sharing, stop share. Sorry to be so technologically incompetent.
Also, if you press screen share and then instead of whole screen, just the PowerPoint window. No, that's your whole screen again, I think. Yeah, if you click on the green button that says share screen.
Yes, I've done that. I've done that.
And so there should be various windows. One of the options will say screen, but that will show your whole screen, which we don't want to see. We just want to see the PowerPoint. I wonder if it's got a picture of your PowerPoint there as an open window that you can click on.
It does, and it's not working for some reason.
Well, if you press your whole screen again and then expand the PowerPoint to fill up your whole screen, that will probably likely do the same thing.
Does that help now?
Yes, I think you've done it. So if you just press, if you press play from the start, you'll see the top left corner. There's a button that says play from the start. If you press that, you should launch your presentation.
I'm sorry to be so silly, but I don't see that dropping anywhere.
You see, it's just disappeared. If you go up to slideshow, do you see the word slideshow in the top row?
Yeah.
Click on that. Now play from the start. Yeah. There you go.
Thank you. Good afternoon, everyone. It's a great pleasure to be here. I thought that I would try and speak for about 20 minutes, not about how to carry out virtual arbitrations, because reams have been written and volumes have been spoken about how that should be done. Although I must say I rather share Lucy Reed's enthusiasm for virtual hearings. It's you miss, don't you? You miss the raised eyebrow and the whispered aside and the heavy sigh from the bench when you're doing virtual hearings. At the moment, they're happening nearly every day. They're very good for simple procedural matters, but they're very, I think, quite difficult for acute cross-examination or sensitive presentation. In Scotland, we've had an arbitration act for 10 years. In the 300 years before that time, the Parliament of Scotland, or the Westminster Parliament governing Scotland, only saw fit to interfere in the matter of arbitration on 3 occasions. And on none of those occasions was the interference complete. And so it's not surprising that we didn't have a codified form of regulation for arbitration until the 20th century, the 21st century, really, thanks to the enthusiasm of the profession. The late Ian Murray, Lord de Vere it was, who picked up the idea that Scotland should have its own Arbitration Act. And indeed, so selfless was he in promoting it that he drafted his own act and presented it to the pre-devolution administration, who thanked him graciously and put it on a shelf. It's a great credit to the post-devolution administration that the idea was picked up on and resulted in the 2010 Act. And that taught me that if you want to get things done in government, you have to get it put into a party manifesto, and then that party has to win the election. So why do we arbitrate? What kind of law is it that we're trying to apply? Is it the commercial law of our own country? Or is it something inchoate, floating in the sky, that we generally call the lex mercatoria, the business of commerce across the world? Does your own country facilitate that, or does it hinder it? Is your own country jealous, or is it open-minded about the kind of law that it applies? In Scotland, I think we're lucky because of our mixed Roman-Dutch heritage and common law adaptation. We can look in both directions at once and choose the best. And that is really what happened with arbitration in the first 10 years of the 21st century and the late 90s. The pressure wasn't intense, but it was gentle and persistent. And in the end, rather like England and Wales, the 2010 Act emerged. Why do we need it? We need it because sometimes courts find it difficult to produce quick outcomes for business. I don't think we can say that there was public discontent, but there was probably discontent among the legal community that so much work of this kind went south. There was also discontent that we didn't seem to manage to control what went into dispute resolution clauses. However, we have a much longer history than that, formal and informal, of arbitration by men of skill and not just lawyers. And that's what we've tried to put into the 2010 Act. It would take me all afternoon to rehearse the struggle that went on with the language, but what we were aiming for was something that would suit as many people as possible, that would suit international clients, but not only international clients, not only people with money, but small-time domestic cases, which could be resolved by a skilled arbitrator. In the early years, we floated the family law arbitration scheme long before the family law arbitrators took charge of it themselves, and advanced the possibility at various seminars that matters which took months or years through the courts could be resolved by the amicable arbitration of a skilled practitioner, chosen by the parties at reasonable cost, and people's dirty linen could be kept from the public eye. These decisions could be made quickly and they could be final. And an arbitrator could be used to bring people as close together as he or she could. I'm reminded, just looking down here, Lucy was talking about flexibility and adaptability. And that was very much the watchword of what we were about in the late 90s and early 2000s. I'm wearing a badge on my shirt here, which you probably can't see from a distance, but I'm very proud to wear my Arbitral Women badge, not making some great gender point, but just to show that we must shed all our preconceptions when it comes to arbitration and not be judgmental before we've heard what everybody has to say. What sort of legislation did we want? What sort of rules should we use? Should we just copy from other jurisdictions, or should we try and invent something homegrown? The model law, of course, provides a paradigm for the civil law countries, and we all know its origins. We also know that in 1996, Lord Mustall and the cohorts of that time pressured the DTI to produce the 1996 Act, a piece of legislation which has stood the test of time very well and has proved to be flexible, adaptable, useful, and more or less lawyer-proof in the time that it's been in existence. A very fine homemade product. The Scottish Act borrows from it where it's perceived to be useful in the Scottish context. We wondered about rules. We looked at, of course, there are hundreds of sets of rules, dozens of sets of rules perhaps across the world. We looked at those and spent endless nights poring over this rule or that rule in different languages to see what might work in Scotland. And I don't remember who it was who hit on the idea that the rules could conveniently form part of the legislation. Now, it's not unique to Scotland, but it's certainly one of a very small number of institutional pieces of legislation that has the rules tucked in the back. New Zealand, I think, does the same thing. And the great advantage of this is, A, all the laws in one place, and B, if you want to change something because of circumstances, you don't have to legislate. You simply use subordinate legislation or ministerial order to do that. It's quick, it's cheap, it's convenient, and it's expedient, and it takes account of commercial circumstances. The rules themselves, which are numerous, I can't now remember how many, are either inclusive or exclusive. Some are mandatory, some may be followed or may be excluded. I don't want to go, and I don't have time to go through the minutiae of that today. But the whole point is that they're easy to follow, and they're readable, and they're understandable. And as well as tying down the parties to a process that makes sense, they tie down the decision maker or decision makers, enjoining him to perform quickly, perform expediently, perform properly, and to produce finality, what I've called their future proofing. We're all told, as the Minister told us a little while ago, that arbitration's signal advantages are speed, efficiency, privacy, confidentiality, and cost. It's not always true, and we know that because cases do slip up, and sometimes they get into incompetent hands, and sometimes they last far too long and cost too much. But if you don't start with a good theory, then you can't finish with a good product. And the good theory is that by choosing a judge who's got proven competence, you should be embarking upon a process which has as its hallmarks efficiency and economy. In other words, not allowing for endless pleadings, endless adjournments, reams of paper. And you should be able to do that in a private or confidential atmosphere. The Scottish Act legislates for confidentiality. The 1996 doesn't do that. 1996 Act doesn't do that, but it is an implied duty in English law. And I like to think that by legislating for confidentiality, we have achieved a little step to enhance the reputation of arbitration where it is used. For corporate people in particular, professional and corporate reputations can be very important. A stock market shift can be caused by poor reputation. Remember Gerald Ratner and the jewelry that he sold. And so where disputes are conducted in private and are able to be conducted in private in a way which guarantees an outcome, it doesn't have to be a friendly outcome, but an outcome which is private, then there is a widespread perception that that is an asset to the process. What do we have in Scotland? We have a substantial legal profession which is spread right across the country, all of whom have enjoyed more or less the same kind of legal education. I generalize, of course. Glaswegians would probably not agree that Edinburgh had this as good a legal education as they did, and vice versa. However, the fact is that our young lawyers all do more or less the same things and are trained in more or less the same way. This means that there's a unanimity of understanding, or there should be, about concepts of contract, delict, property, misrepresentation, fraud, crime, and all the rest of it. You don't have to explain the basics. We have supportive courts, and the rules themselves and the cases which, and there have been very few of them, which have come forward since 2010, the cases tell us that the courts are supportive of the concept of arbitration. If parties agree to private judgment, Scotland is a modern country. Its connections are good, its transport is usually good, except in bad weather. Its support services are good, and it has very attractive locations, as those who come to ICA next year will surely see for themselves. If you have a choice between, I don't know, a fortnight in a hotel in St. Andrews, or a fortnight in a large industrial city in the middle of Europe to do your arbitration, you might think that a fortnight in St. Andrews is quite an attractive option. It's easy to get to. Relatively speaking, it's cheap. And you come away the better for the experience. I'm sure that when ICA comes next year, this is going to be a massive selling point for Scottish arbitration, the attractiveness of the venues that we can provide. Just touching quickly on what the Minister said and what Lucy said, of course, with our equipment now, we can go anywhere. You can do an arbitration on an iPad. You can do it sitting in a hotel waiting room, an airport. You can use anybody's rules if you contract into them, and you can easily find the best people who can be paid in any currency. Now, enforcement's a big question, and I'm not going to go there today because I haven't got time to talk about the New York Convention. But just think about it. If you're in Dubai airport and you want to see if you can do something about selecting a German arbitrator, and you have an iPad with you, then assuming that they're not asleep at the other end, you can make contact, you can make the initial approach, you can settle fees, you can agree rules, you can do all of that minutiae simply sitting in your armchair. And so, dare I suggest it, that might be a positive side benefit of the pandemic, that we've all learnt better to communicate with our friends and colleagues across the other side of the world. Only today I had an email from a colleague in Melbourne, Australia, telling me about the outcome of a case. Now, of course, that could have happened by email at any time. That's familiar enough now. But even, 15 years ago, it might have taken a few days and a letter to get that news to me. As it is, we've had the dialogue. The job is done in half an hour. I'm going to nearly finish by returning to one of my own bugbears, and at the risk of perhaps sounding critical of my own country. The key to success of training arbitrators and dispute resolvers in any country has to be training. We are very fortunate that we have an arbitration centre which is not only supported by our government, but also by a whole host of professional bodies. And after 10 years, it's striking out on its own as it makes its way in the arbitration world. We have to, I think, in order to gain status in the modern world, look a little more widely and train a little more fully, so that the practice of arbitration doesn't simply become something that one learns by osmosis. As you develop some gray hair and a wider waistline, you think, oh, well, I may become a dispute resolver. It isn't done that way now, and it shouldn't be done that way in Scotland. We should be training in a forcible way, not simply gathering people in once in a while, not simply mixing people up 2, 3, 4 times a year, but focusing in the universities and postgraduate and during the younger practitioners' professional lives on this as a real skill requiring real excellence and an international outlook, so that they can stand up in front of an arbitrator and say, here's an authority from Canada, here's an authority from Western Australia, here's an authority from Germany, here's an authority from Scotland. I have the great privilege of reading memoranda for the Vis Moot, which, as you know, takes place in Hong Kong and Vienna. And it is very striking how easy and impressive it is to read memoranda from students from, what should we say, less well-developed countries, and to see the quality of the research that they have put in. The internet enables all this, and they're taught to do it, and they do it. And I think we lag behind, dare I say it, in Scotland in that regard. As Scotland becomes more economically grown up and having to cope with Brexit or perhaps re-entry to the European Union, perhaps not, we don't know, we're going to have more sophisticated clients, more sophisticated government people, and more sophisticated individuals who will have an international outlook. We need them to be satisfied with our outcome, because if they're not, they will hop on the train to London, where they will find more expensive lawyers, more expensive venues, more expensive practitioners, and more complicated rules and longer processes. One of the mysteries that's I've never solved is, why is London so successful when it's so much more expensive? And the only conclusion I can come to is that people like spending money. So thank you very much for the invitation to speak. As I say there, this talk is just a stepping stone. There are many other ways of resolving disputes, but this is the best, and we can be the best here. And I'm confident that in September, we will show the world just that. So thank you, Brandon. I'm much obliged. And thank you, everybody, for listening.
Okay, thank you very much.
I thought for a horrible moment there, I've been speaking to an empty room for 20 minutes.
No, we were here and we heard it all. Yes, call to arms on education, strong stuff, and even getting a little bit political there, John. Any Q&A? Any Q&A for John? I'll not start discussing politics with you here. Maybe do it later. That was fun. So thank you very much for that, John. We'll keep. Are you staying around to the end, John?
I'd like to do that for a little while. Yes, thank you.
So we haven't had any activity in the Q&A yet. Please do, if you have questions, ask it there as we go along. And John's going to be here, so we'll see how time works out. But we're now going to move on to our final session, the panel session. So if I could ask my fellow speakers to show themselves.
Themselves like that.
Sam there. There she is. Okay, and a slight change to program. I'm afraid that the advertised Justin D'Agostino has been detained at the very last minute and has been able to join us, and he regrets that he's not able to join us. Justin, of course, is an Edinburgh native, but also CEO of Herbert Smith Freehills, overseeing people practices, clients, and growth strategy from his base in Hong Kong. So it's a great pity he's not able to join us. But we are joined by Paul Cohen. Paul heads the international group at 45 Grayson Square Chambers in London. He's called to the bars of New York and England and Wales. He's particularly well known in his work for his work in energy, finance, and technology sectors. And he has appeared in commercial disputes involving all the major arbitral institutions, as well as in ad hoc arbitrations. He's co-chair of the International Task Force at the Silicon Valley Arbitration and Mediation Center, editor-in-chief of the Journal of Technology and International Arbitration, and sits with me on the Cybersecurity and International Arbitration Working Group. Welcome, Paul, from San Francisco, as you can see by his background, although I don't think that's the view from his living room, could be wrong. We also have Samantha Cummings with us. Now, Samantha, also a fellow Scot, is a senior associate at Sidley in London. Her practice focuses on complex commercial litigation, arbitration, and contentious restructuring and insolvency work. And her arbitration experience includes cases conducted under ICC, LCIA, UNCITRAL arbitration rules with seats in London and Singapore. And although a solicitor in England and Wales, as I say, Samantha's from Edinburgh and is one of the ambassadors for the centre. So welcome, Samantha. Now you're both on mute. Please come off mute. There we go. So this session will take the form of a bit of a Q&A, and we're looking essentially at technology issues, a wide range of technology issues. And we'll start off with a theme that Lucy was talking about earlier, virtual arbitration. So I thought I would just start off by asking what has been your experience of virtual arbitrations to date? And I'll ask Sam first, because I know she's had a very recent experience of doing this.
Yeah, so we had a final hearing in July. It was ICC arbitration and was supposed to be seated in Singapore, but that didn't happen. The parties ultimately agreed to a virtual hearing conducted over Teams platform. We obviously, our legal team is in London. Our client was in Chicago and in Texas in the US. The other side was in South Korea, and there was a sole arbitrator in New Zealand. So obviously, and then the chambers in Singapore hosting. So there were a number of challenges initially with setting up a hearing that could be conducted over the time zones, which meant that people weren't awake for all hours of the night. Ultimately, our client had to give evidence at 4 a.m. in the morning, his time. The other side's key witness had to give evidence at 1 a.m. their time. So both sides made sacrifices in that regard. But broadly, the virtual hearing went really smoothly. From a technical point of view, we had 2 test runs, as the ICC suggests and proposes that the parties do, and that went smoothly. The technology and the platforms that each side used were fine. There were, however, sort of inherent challenges with using or being virtual, which I think were which we overcame. But I think were most important was the issue of cross-examining the other side's witness and assessing that witness's credibility over a camera. It was difficult to, it's hard to pick up on tone, and when you're not looking someone in the eye, to cross-examine and assess the credibility of that witness. There was issues with presenting evidence, so whether you share screens, and the sort of confidentiality and security issues with doing that. There was issues with simultaneous translations, so the other side's witness was giving evidence in Korean, and whether how you managed translations in that regard. So there were a number of inherent issues with doing it virtually, but actually it went really smoothly in the end, and it was under the expedited ICC rules. So we've had our award now, and it was fine. And I would hope to see that kind of procedure implemented going forward, actually.
Okay, so the things you would expect with a virtual hearing, the things people complain about, whether you can cross-examine effectively and judge people's reactions, these are the common complaints. And it's interesting that you raised that in practice that was a bit of an issue, although you seem satisfied with the process. Now, Paul, you're a bit of a trailblazer in online hearings, and you've been a big advocate for the use of the format, even before a long time before the crisis, the pandemic, and it was you, in fact, who introduced me to Zoom a number of years ago. So this is your natural environment. So what's your experience been? What's your thoughts, Paul?
Well, I just had my morning cup of tea here, so it's just a bit past 7 a.m. So the caffeine hasn't quite circulated, and I'm a bit grouchy. So forgive me if I'll probably mellow in the next few minutes. But I feel like I sort of have to call bullshit on the whole idea that as a community, arbitration, international arbitration in particular, is marked by flexibility and adaptability. This technology, as you say, Brandon, has been around for decades, really, and it's had its bumps in the road, and it's still not perfect, but it has been possible to conduct essentially elements of a virtual arbitration now for well over a decade. There are disadvantages, to be sure, that you can't overcome, such as the time zone issues that Sam was just referring to and that Lucy referred to as well. They are, I suppose, countervailed, if that's a word, or there are countervailing considerations, such as if you all have to show up in Singapore or wherever at a particular time and place for a few weeks, there will be issues of jet lag. So, 6 of one, half a dozen of the other, as far as I'm concerned. But the idea that that we are somehow, as a community, and I'm speaking now of the international arbitration community, that we are somehow nimble and flexible, I think is belied by the fact that it has taken a once-in-a-century pandemic for us to adapt and adopt this kind of technology. There are definitely disadvantages to it. There are issues, as Sam has said. There is the issue of assessing witness credibility, which is, as you said, Brandon, I think one of the main objections I think that you get here. And let me just offer a few observations about that objection, because it is the one I think that comes up most frequently. Number one, it's an objection that you will find almost exclusively among common lawyers. So what you might call Anglo-Americans, but of course I include the Scots, forgive me for using that term, but the Anglo-Saxon, the common law world, and again, I know Scotland is not a common law jurisdiction exclusively, but the world in which cross-examination is not unheard of. I don't think any civil lawyer in continental Europe would ever complain about this sort of thing, because cross-examination is essentially alien to that practice. Number two, I think that you have to look at the research and say, and I say this as someone who loves cross-examination and fools himself into thinking he's good at it, that the evidence of our ability to gauge the accuracy of what a witness is saying is actually woeful. Study after study psychologically has shown that no matter how good we think we are at teasing out the truth from witnesses in cross-examinations, in police investigations, in what have you, even as quasi-professionals, we do a little better than chance. So it gives us a good, warm, fuzzy feeling to be able to say, yes, well, I really cross-examined the crap out of that witness and so on and so forth, and look at the way they, they looked fearful when I asked that question. But the truth is that we're not particularly effective at getting out the truth out of people. It's a bit of a kabuki theater, a necessary kabuki theater, again, in the common law, but nonetheless, that's, I think, what it is. Number three, there are ways of adapting to cross-examination virtually, and I've had trouble doing this myself, and this is what I call the William Shatner problem, being a huge Star Trek nerd myself. And that is that, again, as John mentioned, when you go online, you don't get the size, the asides, some of the little details that you see in person. It's a different medium and it demands adaptation. Much as William Shatner, William Shatner, by the way, is the original Captain Kirk, for those of you who don't know, in the Star Trek series of the 1960s. An accomplished stage actor who didn't quite, I think, learn to adapt his acting skills to television, and therefore was constantly, over-egging it, hamming it up, doing things like this, using his hands. And I look ridiculous when I'm doing this on a screen. I might still look ridiculous doing something like that in person, but I will look somewhat less ridiculous. So we have to adapt our manners of advocacy and our manners of witness testimony and our manners of being an arbitrator. So those are my thoughts about the virtual world and the adaptation to it. I have to agree with Lucy that I suspect, for better or worse, that when this pandemic is over, people will rush back to the in-person arbitration, for better or worse.
Well, that's a neat segue into my next question. Well done for teeing that up there, Paul. That's the question, isn't it? When we get this vaccine, which is now apparently happening next week, fantastic, and therefore return to normality as it's rolled out across the country, across the world. Is everyone going to go back to physical hearings, or what have we learned? What do you think, Sam?
I would hope that we would maintain, that we would use physical, virtual hearings for at least some of the hearings that we have to conduct. Our final hearing in July was supposed to be in Singapore, but the quantum of the claim really wouldn't have stood up to, teams of lawyers descending on Singapore for a week. It just, it wasn't cost effective really, and actually the way that it turned out, it was quicker to do it virtually and cheaper. I think though that sometimes with final hearings in particular, and it's a minor point, but and it varies obviously with clients, but sometimes clients having litigated for years quite like the feeling of turning up at court at the end of it. Is a cathartic feeling sometimes, and even where we've settled cases like on the steps of court, the client sometimes has just gone into the courtroom anyway just to have a look, and I feel like they feel they've incurred the time and the cost, and this is the pinnacle of where they wanted to get to, and they sometimes like that ultimate feeling of being physically present somewhere. But I would hope that virtual hearings are here to stay to a certain extent.
Yeah, people like their day in court, don't they? Day in court, even
Yeah.
if we're talking about arbitration. Yeah, it's interesting. You mentioned about cost, and obviously cost is a very significant factor. It's cost savings. Paul mentioned it as well. So is there a tipping point? And it's international arbitration, but it's also domestic arbitration. If everyone is gathered in one large venue, there's a cost involved with that. There's the venue hire potentially. There's the catering instead of nipping through your kitchen for a sandwich. There's a lot that goes with it. There's all the travel costs, albeit if it's domestic, that's going to be less. So is there a tipping point where the benefit or the perceived benefit of an in-person hearing is outweighed by the cost savings? What is the range there? And I suppose the other side of that coin is there the potential to increase access to justice because of the potentially lower costs involved? What do you think about that, Paul?
Yeah, absolutely. I think you see that in the fact that the one realm of online or virtual arbitration that's really flourished even before this pandemic has been in consumer disputes and with eBay and a dispute resolution organization called Modria, which provides online dispute resolution for small dollar stuff. These are people who would literally not have had their day in court, but for the ability to do this online. Now, we see with this technology that we are capable of having much more sophisticated, large-scale arbitrations for much higher dollar values. But as you said, as Sam said, people will ultimately, eventually want to have some catharsis, and that may still mean for a certain generation of person, or may mean for anyone, that they want something physical before a physical arbitrator, a real person in real life. I don't know where that dollar figure will, where that tipping point comes. I suspect it has gone up given the past experience, but huge hypocrite that I am, for example, despite my evangelism for this stuff, I have the final hearing for as an advocate in an arbitration that's gone on for several years in February and in Europe, and it's worth many billions of dollars. And come hell or high water, I will be there in person, even if I have to quarantine for several weeks beforehand. So, and I think the clients would insist that I be there. So I think we have a residual feeling, because we are human beings and social animals, and we're not programmed or evolved to deal with this stuff. To want some kind of human interaction across the space or across a physical space. Now, the only thing I might throw out is we're talking about video here, which is a very artificial form of remote reality. There are more sophisticated forms of remote reality under development, and those might better mimic the experience of being in person. And so we should look out for that in the years to come to see whether that might give us the satisfaction that this two-dimensional video does not.
Okay, back to Star Trek then, potentially.
Star Trek. Everything comes back to Star Trek for me.
Well, of course. We have a question from Craig Connell QC. He asks, will some clients say that for cost reasons they will swallow any failings of an online process? Very much what we're talking about here, and I think there are parallels if we think about certainly in Scotland and in the UK and some other jurisdictions. We have adjudication, which is for construction disputes, and that's a very rapid process, 28-day process, and necessarily therefore it's rough justice. You don't get to go into the issues in the same way. You don't get to fully mature the case and get a fully reasoned out argument and decision. And yet it's extremely popular. And even though it's temporarily binding, people tend to, in most cases, just stop there with the adjudication. People accept the outcome. They've had their day in court that we were talking about. They've put their case before a neutral person, and they're happy to leave it there. And perhaps there's a similar argument there that Craig's picked up on, that if you get your process, even though it's a quicker, cheaper, dirtier process, you've had the process, you've had your day in court, and you get a result. And particularly in these days where everyone's very cost conscious, and increasingly so with arbitration, maybe that will be, now that we have proof of concept for virtual hearings, maybe that will be the thing that tips it over the edge into a much more mainstream way of doing things, even after we get a vaccine.
To agree with you vigorously. In the end, whatever dispute resolution process we use is necessarily some form of curtailed dispute resolution process. We could, in an in-person arbitration, we could always do a lot more. We could have, for example, depositions, which is a standard civil procedure mechanism, sort of an in-person interview, sworn interview that you have in US procedure. We don't do that. We can have much more extensive document production where you can always cross-examine people more. It's always a question of where you draw the line. And so, yeah, at some point I think people will say to themselves, yeah, enough. I've had my bit. That's fine. And end of story. I can move on, back to business.
Yeah, yeah. Well, that's fascinating chat about that topic. I think we have to try and cover some of the other ground that we're looking at. The next topic is cybersecurity. And Lucy mentioned this. I have an interest in it. You're on that working group as well, Paul. And it gets a lot of press. And of course, there are various guides. There's the ICA New York City Bar CPR one that we talked about. I know the IBA has a more general guide on cybersecurity. And that the ICC are looking again at their guidance on the subject. What level of attention do you find that this is getting in practice? Are parties actually adopting case-specific cybersecurity measures, or is it more of a, well, our firm's general practice is this, or my own practice is general practice on cybersecurity is this policy here, or actually is it still being ignored to a large extent? What's your experience?
Ladies first.
Sam?
So just to use our hearing in July, for example, we adopted, the ICC was quite early, I think, in putting out their guidance on COVID measures, and we adopted the suggested clauses that they had annexed to that guidance in our procedural orders for the final hearing. And that included, cybersecurity suggestions, including, that the parties had to have, a platform that was sufficiently of good quality to host the hearing, that we would have a number of test runs, that the parties had to identify whether there were any local law issues with, the proposals being made, and the virtual hearing that was going to go ahead. So, and all of that worked really well for us. The parties sort of followed that guidance. Everything went really smoothly from a security point of view. We didn't particularly concentrate on it. We made sure it worked, and each party was happy with the level of security there. But, it wasn't something that, we weren't particularly, we didn't concentrate on it. The other side being in Seoul and the arbitration being seated in Singapore, there weren't, issues to do with connectivity or in those jurisdictions.
But in terms of things like specific measures, if you've got a very sensitive case where the subject matter is very sensitive, or potentially a high value case that might be a target for a hack, are we hearing of people adopting case specific measures on data storage, data transfer, restriction on communication, password protocols, anything like that? I personally haven't seen it yet, I have to say. And when I raise it with parties as an arbitrator, I think it's because the cases I've dealt with since all of this came to the fore have not been sufficiently sensitive that people have been terribly worried about it, and they just say, well, we'll just go with our usual measures. We have our usual measures, we'll just stick with them. And it may only be, perhaps we'll find it may only be that it's in very sensitive cases where people are looking at this specifically, or it may just be there's still a big learning exercise to go through. Do you have any thoughts on this, Paul?
Yeah, like you, I haven't come across specific concerns in the cases I've been involved with since the protocol came down. But I think it may be, as you say, an instance of it's the kind of event that might happen, but until you come across it, you don't really think about it. Like, for instance, some giant pandemic that might hit. So once it does, then it's all you think about. So I suspect that, and I hope that the protocol that's in place really provides a framework for those people where there is a real sensitive issue. And I have to say my misgivings, as you know, just letting out the secret of the deliberations of the task force, my initial misgiving was that we were not specific enough about some of the measures that could be taken in the case of some kind of cybersecurity concerns, and I was overruled in terms of having a more general approach, and I was wrong, and the rest of the committee the task force was right about that. I think the flexibility of the protocol is what makes it useful, because these kinds of issues can appear in all sorts of different shapes and sizes, and the point is to alert people to the risk and then ask them to take the measures as they see fit, not to impose specific measures on them as a gold standard.
Yeah, I mean, I should mention, I've put, if you look at the chat, I've put a link to the ICA cybersecurity protocol on there. Please do go to the ICA website and the page there and download it and have a look at what we're talking about if you haven't already seen it. But sure, I mean, we now that we've moved to a much more online environment, and it's every day, I think there's a steady move to everything being electronic. Certainly with documents, it seems everything is now done electronically, and printed documents are the exception rather than the rule, and of course now hearings since the crisis, and there is obviously advantage to be gained and mischief to be made if these high value arbitrations are breached, if they're hacked. If I'm as a hacker able to, for example, hack into the deliberations of the tribunal and find out what the result is going to be in a big arbitration before it's published, I can make all kinds of merry mischief with that, possibly hacking into or influencing the markets, perhaps even influencing currencies in a big ICSID arbitration. So pretty serious stuff, and I still have a feeling that it's not being taken as seriously as it should be, but we'll see. Well, thanks. Andrew has posted the link. I've posted it to the panelists by mistake, but yes, it's up for everyone now. So do have a look at that. And just finishing on cybersecurity, do we feel that institutional rules are covering the cybersecurity adequately? You mentioned, Sam, specifically that the ICC addressed this issue in their rules.
Yeah, so in the guidance, I don't really feel that the rules need to particularly change. I'm in the same position that you are, and that our clients really haven't raised cybersecurity issues, and I think the rules are flexible enough, and the guidance is there so that we don't really need to. If we feel in the future that we need to implement specific security measures, then we can, I think, under the rules as they are.
Okay, well, let's move on a bit, quite a bit. In fact, we're going to start. We've been talking about the present and the crisis and the technology that we've all been using, albeit it's been forced upon us to an extent. We're going to look a bit towards the future now, and we're going to talk about blockchain and smart contracts, and these are technologies certainly that are there. They're being used, they've been around for a while, and they're being used extensively in some quarters. And how is this impacting on arbitration? Obviously, blockchain, it can be used to support the process, but it can also replace arbitration altogether. And there is the example of Kleros, the system there, where we're getting crowd justice. And in the case of very advanced smart contracts, you can actually remove the possibility of a dispute, or more or less remove the possibility of a dispute by anticipating the possible outcomes and catering for them in code, so that there simply can't be a dispute unless there's a mistake with the code or some sort of external hacking. So where do you see blockchain having the biggest impact in the short term, the medium term, the long term? What are your thoughts on this, Paul?
In the short term, I think the smart contracts that you just mentioned are what we will see replace what might otherwise have been some small to medium arbitrations. Without going into detail about smart contracts, it's essentially you have a contract, but it's executed in code so that you just go through step by step by step, and the payment is often rendered through a blockchain currency, what do you call this? Cryptocurrency, like a Bitcoin or Ethereum or something like that. So that once all the steps of the contract are complete, the payment goes through, and end of story. So I think people are starting to use those. Mostly in the sort of tech-related industries, we will probably see fewer disputes than we might otherwise have seen in that sphere. In the medium to long term, you mentioned dispute resolution outfits like Kleros, which are very interesting. They are not arbitration at all, as we understand it, though they do refer to themselves as arbitration. They are, as you say, the wisdom of crowds, where a bunch of people online get to resolve a dispute by essentially having some cryptocurrency skin in the game and deciding who's right and who's wrong. It's very quick. That's one of the temptations to sign on to it. It's very final, it's very definitive. It's not, as I said, a reasoned arbitration in any sense that we understand it, but I think that if I may, the younger generation, some of the younger practitioners who are really into this stuff, have seen it as a real threat to modern arbitration as it currently exists. And it may be that a generation of people, again younger than myself, prefers it to the long drawn out processes that we currently have, and that may be one of the threats to arbitration on the horizon.
Yeah, I mean, just to give a very brief mention to what a smart contract can do, or an example of one, you have a thing called parametric insurance, and that is you get a predefined set of parameters, and if something happens, you get paid out. So if I take, so for example, the first one they used was that I can think of as PhysiAXA, which is travel insurance or flight delay insurance. They're no longer operating, as it happens, which maybe tells us something. Essentially, you pay a premium, and then if your flight is delayed by more than 2 hours, you get paid out automatically. You don't have to claim. You just get paid out, as Paul says. That might be with a cryptocurrency. Another example is crop insurance. So, for example, crops that are susceptible to damage by frost. I went to high school in Florida, and there we had in Citrus County, as it happens. And every year it was always a worry: is the frost going to affect the fruit? Because if the frost damages the fruit, you can't sell it as fruit. You have to sell it for juice, and you get a lower price. So you can insure against that. And it happens automatically because there are sensors connected to the weather stations. And if the temperature drops below a level, the policy pays out. So you don't have to appoint a loss adjusters. There's no argument between the lawyers. You can't have an arbitration or a court case about it. So that whole realm of dispute is just taken out of the picture. And as technology advances, and and we'll come to talk a bit about artificial intelligence and what have you, but as systems become more and more able to cater for eventualities in a contractual situation, we may find that many areas of dispute are simply removed. So that's exciting stuff. We had Richard Susskind give the Alexander lecture the other day for CIR when he was talking about this kind of thing. And we're kind of approaching the technology question arguably from the wrong angle. Not so much how is it going to affect arbitration, how is it going to affect the concept of how people interact. So exciting stuff. Now, artificial intelligence. There's a subject. So, Paul, you write a lot about artificial intelligence. What are you seeing applications, AI applications in the arbitration world at the moment? And what do you think that we can expect? Is the robot coming for our jobs as arbitrators?
Not yet, not anytime soon. So I think we're sufficiently familiar with AI now that we don't need to really explain what it is. At least I hope so. But we do see some nascent AI programs, they're not so nascent actually, fairly established AI programs now in terms of the organization of documents, the production of documents. This was pioneered in the US where, as you know, document production issues are much more robust and onerous in civil litigation than they are elsewhere in the world. And the idea is that a computer program, an AI program, can sort through relevant documents and identify relevant issues in a document much more quickly than a human can. And that is the principal application we've seen so far in the law. So for that reason, it's probably less prominent in international arbitrations than it is elsewhere, simply because we don't have the document production issues that we have in US litigation. That said, that application is, you're beginning to see that application in terms of research on legal issues where the same principles apply. A program is going to be able to sort through and find the relevant case law much more quickly than a human lawyer is going to be able to do. You see it also in the question of sort of selection of arbitrators. There are some people now purporting to be able to tell you something about predict how an arbitrator is going to rule, or which arbitrator you should possibly pick for which kind of dispute. I'm a little skeptical about these particular programs simply because what little I know about AI tells me that these are data-heavy programs. In other words, the more data you have, the more accurate they are. And given arbitration's relatively small size, its confidentiality and the inability to know everything about the caseload, the case law out there, it may not be as accurate as predicted, unlike, for example, if you have the whole body of Scottish law or English law or US law or what have you, where you have literally millions of cases and are probably able to make a more accurate prediction. But that's where you're seeing it. We're not quite at the phase technologically where we could have a robot arbitrator sit there and sit in the stead of a human. We will be there, and I don't think it's going to be that long. I'm guessing within 10 to 20 years. We're probably almost to the phase where you can have a tribunal secretary be a robot of some kind. That's probably only 5 years away.
Okay. Sam, an optimist or a pessimist on this particular subject?
I don't know how a robot arbitrator could take over anybody's job at this point. I mean, as far as like dispute resolution is concerned, the only thing I'm aware of that works is the website that allows you to dispute your parking tickets in London, and that I ought to get some sort of subscription to because I really need it, and I think it works from what I've read. But I mean, I don't really think that, and also I'm aware that there are programs that say that they can help you choose an arbitrator for the particular dispute you've got, and weirdly our clients have shown quite a lot of interest in that, although we haven't implemented it so far. But as far as adjudication is concerned, I personally, and maybe it's just I just don't really understand enough about algorithms, but don't understand how an algorithm that ultimately is written by a human could be any less fallible or less prone to bias or more standardized than a selection than the sort of process of selection that we go through at the moment. I don't understand it, but Maybe I'm too old. Don't know.
Well, if you're too old, there's no hope for
God,
me.
yeah, if you're too old, God help us.
Yeah, I mean, I have to say, my own view is that it must be the case, and I think this is because of advances in technology that are looming, and this sort of brings us on to our final tech topic, which is quantum computing. Because quantum, it appears that Google and NASA they say they have achieved quantum supremacy, which is that they have got a computer which is capable of doing something which a traditional computer simply can't do. That's disputed by IBM and various people. But in terms of power, the power of the quantum computer is so much more powerful than what we would understand a computer to be able to do that we currently have. As I understand it, it is literally 1 billion times faster. So a calculation that would take the fastest computers that we have at the moment, something like 10,000 years. So a very, very difficult calculation. The quantum computer that Google and NASA have can do in a matter of minutes. It's simply not possible to comprehend that advance in power and the change that has the potential to bring about. Now, as I understand it, that test has been done on a slightly abstract calculation, and it's not what you would call a practical use of that type of computing power. But when that comes on stream properly, if you apply that kind of power to the current AI abilities that we have, it's difficult to see how, if you have an AI that has the whole of human knowledge, or a computer that has the whole of human knowledge, not just the law of here, of the law of there, or what somebody has decided, or what everybody has decided, but the whole of recorded history in a little chip the size of the end of your pinky, and then you multiply that to the size of a room. We are on the brink, I think, of another technological revolution, and it's quite scary to think about how that might pan out. And it's absolutely true that if you put rubbish in, you get rubbish out. But what if you put everything in? And this is what we don't know, and it remains to be seen. So that's a very interesting question. But another, and it comes back to an extent to this day in court argument, and this, will people take it? If you're a client with a very big and expensive dispute, are you going to be willing to give it to an AI program? Now, it might be that this AI program doesn't get tired, doesn't get hungry, doesn't cost you anything, isn't biased, is incapable of bias, and knows the whole of the law and the whole of human nature and the whole of human history, and is going to give you the perfect answer. And you put in your problem and it comes back out in 2 seconds. Would you accept it? At the moment, we have this process that takes months, and you get a result back at the end. You've had your day in court, you've put it all over, and there's a deliberation by people that you have looked in the eye and you trust, and you get an outcome, and you weigh it up, and by and large you accept it. If your lawyer feeds all of this into machine and 2 seconds later you get the outcome, you lose, are people going to be able to accept that? And I think that's a really very interesting question. What are your thoughts on that, panel? Paul?
Sam, or should I go? Okay. Yeah. Sorry to devolve to Star Trek again, but I think I completely agree with you. This is the issue. Imagine you have an arbitration, and you ask, are you going to have it decided by Captain Kirk or Mr. Spock? Now, Mr. Spock is going to tell you the answer flawlessly and logically in 2 seconds, and you're going to say, well, how the hell did you get there? And he'll say, your question is illogical. I have answered your dispute, and go away. Captain Kirk may give you the wrong decision in the end, but at least he's going to tell you how he got there. And that goes to the heart of the decision-making process and what we're trying to get out of it. So assuming that we have this technology ultimately, and I think for reasons we can discuss, we probably will have it quite soon, that can tell you incredibly quickly and incredibly efficiently who's right and who is wrong in a dispute, how it goes, then we really need to start thinking carefully about, well, what exactly do we want out of the dispute? There are some people, some companies that may actually just want the right or wrong answer so they can move on, settle the accounts and just keep the business transaction going. There will be other people who say, well, no, I don't care in the end who, what the result is. I want the process. I need the procedure. I need to understand. I need to air my disputes, air my grievances. That's an important psychological part of the whole deal. And maybe what we'll find is that we'll have a split practice between folks who prefer a sort of, be it a blockchain-y, smart contract-y kind of way of resolving disputes, or an AI-y way of resolving disputes. There are tons of little disputes and things, so you just plug them in and then you just move on. And perhaps in either larger cases or one-off transactions rather than recurring transactions where you still have a business relationship, or in stuff that seems particularly egregious to one party or the other, they will opt for the human, as it were, in the dispute. But what do you say about quantum computing should not be underestimated? I think the second, well, maybe one of the biggest stories about 2020 is not just the pandemic. It's the election of someone other than Donald Trump to the White House. And I don't mean this in the sort of whole larger politics sense. What I mean is that there will be now people who are an administration that is actually going to be paying attention to the architecture of the future in terms of investing in AI, investing in quantum computing, investing in essentially what's a Cold War between what will be a Cold War or an arms race between the US and China, which China has been winning for the past few years in AI and quantum and these other technologies. Remember that the reason we're doing this right now, the reason we're having this debate, this video over the internet is because of the Cold War and the US government's development of the internet from the ARPANET in the 1960s and 70s. So there's a whole bunch of technology that arose in that context. And I think that the new technology of the 2020s is going to come out of the context of the US-China technological arms race. And I think it's going to be formidable.
Any more thoughts on that, sir?
Just to say that my experience of litigating and arbitrating so far is that I haven't had, been involved in a dispute that hasn't had, that our client hasn't been emotionally connected to in some way. Even the biggest corporate who had no involvement with the particular transaction being disputed is still emotionally involved in the dispute, and they want to be able to look the other side's witness in the eye and ask them questions. They want to be able to look their arbitrator, the judge in the eye and assess them. And I don't know how, I think that's a quality about, justice that people wouldn't want to get away from.
Yeah, I'm sure that's right. There's a big human nature element in this, isn't there? And I think the pushback will come from human nature. But equally, we talked about the access to justice issue and the cost issue, and there are a lot of people at the moment who are simply denied justice because they can't afford the court process, the arbitration process. So I think it's inevitable that if this capability is here, people who can't afford the luxury of the full-blown process are going to want to use the AI process. And then it simply becomes a question of where's that tipping point. We've had a few questions. I see there's one from Brandon Nolan, who's one of our directors, and he's asking, is there a net zero consideration which is relevant to the issue of physical hearings in the context of international arbitration? And I think that applies not just to physical hearings, but actually to what we're talking about just now, this ability to get an answer without having a hearing, without having a case, essentially. So we're coming up to 4. Do we have any final thoughts from our speakers, our panel?
Lots of interesting questions. I'm not sure we have the time to answer them. The questions in themselves are valuable. I noticed Michael Lampert is giving us the answer to like the universe and everything. Hasn't told us what the question is.
Yes, thank you, Michael, for that different from Star Trek pop culture reference. Oh, right. Well, on that happy note, as I say, we're coming up for 4, and we do need to finish on time. So, can I just thank a number of people to thank? Obviously, the current panel. Thank you, Paul and Sam. All of our speakers from today. We've had a rich array of speakers. Can I thank our sponsors, FTI and Roy Andrew? Thank you once again for sponsoring our event. And thank you to ICA for their support. We are having this webinar using the ICA Zoom webinar platform. And finally, of course, thank you to Andrew Mackenzie and Fiona Menges from the Arbitration Centre for organising today. And thank you, of course, to all of you for attending. I very much enjoyed it. I hope you have as well. Thank you all.